Hello and welcome to the Legal Apprentice webinar. I hope you've all had the chance to review Task 1 and all the materials on the website. If you haven't had the chance to do so yet, I'd advise to go and grab them because they will be really useful as we go through. So I'm here today with three lawyers from Kingsley Napley, and they're going to share their expertise on the different areas of law that they practice every single day. Now, the areas of law that they're going to talk about are not the only areas of law that you'll need to use for task one. They are the most useful, but I implore you all to read every single fact sheet so that you've got as much information as possible for answering the questions. And hopefully that should allow you to score as highly as possible and put you in with a really good chance of doing really well in this task. So we each associate is going to go through the different points in the area of law that will help you answer their part of the question, and you might have some questions too as we go along. So what we're going to do is collect all the questions at the end, and I'll field the questions to our panel today. If they come to your head as we go along, feel free to type them to us, but as I said, we'll go back and go over as many as we possibly can at the end. So I guess all that's left to say is good luck. We know task one isn't easy, and well, none of the tasks are easy, but all the information is on the website and will be given to you today in the webinar. So good luck, everybody's in the same boat, and I'm going to hand you over to Chess now, who's going to talk a bit about employment law.
So I'm Francesca, and I'm an associate here in the employment team at Kingsley Napley. I'm going to be talking you through the employment aspects of task one and the kinds of things that you need to be picking out from an employment law angle. So really what I want to do is work through how best you can approach an employment law matter.
So the first slide that's come up there is things you need to be thinking about when you're considering an employment law issue. Now, there's no hard and fast rule here, so I've just listed on the slide there a couple of bullet points for you to think about. So firstly, identify who is involved, because that will help you work out what kind of situation you're dealing with. So who are the employees, who is the employer, and also what contractual documents, if any, govern the relationship between those people. So is there an employment contract in place that sets out the basis of the employment relationship? Does the employer have any policies or procedures which may be relevant? For example, a health and safety policy, maybe a disciplinary policy, something like that. Even if there aren't any policies or procedures in place that the employer has, you may want to think about whether there are any external best practice guidelines or codes that you want to consider. So on the employment law fact sheet, we've mentioned the ACAS Code of Practice. Could that be relevant? Do you need to be looking at that as well? It's also going to be important to consider what background is relevant, because the scenarios include a lot of information, and it's your job to pick out the background that you think is really important that will help you deal with the employment law issue in question. So work through the detail, identify the key facts, and then really assess what has actually happened or could happen in the scenario. So what issue are we really dealing with? Is it a situation where someone has done something wrong? So, for example, they've broken a rule. Is it that they're not doing their job very well? Is it that the employer just doesn't need that person to perform that role anymore? So have a think about those kind of things. The key thing for any lawyer is going to be applying the law to the facts of the case. So if we come on to look at the next slide, it's going to be a case of, like I say, identifying the relevant law and applying those to the facts. So break down the employment law fact sheet. That's going to be your guide as you go through task one. Now, there are certain legal tests that need to be borne in mind when we're thinking about an employment situation. And I've just outlined one of the important ones there on the slide relating to dismissal. So an individual firstly has the right not to be unfairly dismissed if they have 2 years employment with their employer or more. And for an employer to dismiss an employee fairly, they've got to have a fair reason for dismissing them, and they've also got to follow a fair process. Now, in respect of the reason, the employer has to show that the reason or the principal reason as to why they dismissed someone was one of 5 potentially fair reasons that are set out in the Employment Rights Act. And these relate to the capability and qualifications of the individual, their conduct, so whether they've done anything wrong, redundancy, which is where they face losing their job, where there's some kind of legal duty or restriction, which means that the employer can't continue to employ that individual, and whether there's any other kind of substantial reason. Now, once the employer has got their reason for dismissing and they follow their fair process, they're also going to have to show that the decision to dismiss the employee was what's known as being within the range of reasonable responses. Now, that seems like a bit of an awkward term. What does that actually mean in practice? Well, an employment tribunal or a court, for example, will have to consider whether in all the circumstances of the case, so depending on what's happened, the parties involved, the employer's size, the resources that are available to the employer, whether the employer acted reasonably in treating the reason for which they dismissed the employee as a sufficient reason for dismissing them. So what that really means, when you boil it down, is whether the option to dismiss was reasonable, and whether another reasonable employer, with all the facts and the information available to them, would have made a similar decision in the same kind of way. Coming on to the next slide, we're looking at questions really that you need to be asking yourself as you go through this process. So, how long has the person in question been employed? That could be relevant. Well, it is obviously relevant because we've got to establish whether or not they have the 2 years continuous service. Did the employer have a genuinely fair reason for doing what they did? Did they follow a fair and proper process? Is their decision, like we've already said, within the range of reasonable responses? Does the employee have a defence? So, for example, has the employee ever been involved in this kind of thing previously? Have there been repeated disciplinary issues? Have they ever done anything wrong before? Have they got a clean record? Could any of these things have affected the employer's decision when it came to sanctions? So if you look back through the fact sheet, dismissal isn't the only option available to an employer. They can also give an employee a first written warning. It might be a final written warning where there's a previous issue. Someone perhaps hasn't got a clean disciplinary record, and the employer is basically saying that you do this one more time and we will be dismissing you. But in this instance, we're giving you a final written warning. An employer can do things like deprive an employee of a bonus, demand that they need to attend further training so they don't have this problem again and again. So are there any other sanctions that could have been considered? And do any of the above issues, do any of the above questions that you have been asking yourself have an impact on the type of decision which, the type of sanction which an employer could have decided upon? It may be that there's no clear right or wrong answer, and invariably there won't be. In reality, you'll probably be able to answer these questions in a variety of different ways. But the key thing to remember is you need to be forming a view, and you need to be showing your reasoning. Also, if you don't have sufficient information available to you to form a view and to answer these questions, then say that. You know, that's just as relevant as being able to find the answer very clearly and quickly. If you think that important information is missing from the facts of the scenario that would help you form a view, then you ought to be explaining what additional information you think you actually need and the reasons why. We do this kind of thing with clients all the time in practice. You're always attending a meeting with a client, getting a certain amount of background and having to ask additional questions to tease the information out of the client so that you can properly respond to the issue. So key things to remember. I've just set out some final points on this last slide. Break down the problem into manageable chunks. So like I've already said, who's involved, what has happened, what process should have been followed, if any, why was this process not followed, And is it fair or reasonable? Apply the law to the facts of your case. That's the central tenet of being a lawyer. So look at each element of the law and ask yourself why it's relevant given the facts of the scenario. And if it is relevant, how is it relevant? Be clear and concise in your answer. That rather goes without saying. But also don't panic if there's no clear right or wrong answer. It's okay if you need more information on the facts, that's absolutely fine. And show your logic as you go. The point is you're trying to persuade someone as best you can on the basis of the information that you have available and the assumptions that you're able to draw from that information, that you've got to the right conclusion. So I think that's the key thing to remember there. And now I'm going to pass you on to my colleague, Seven.
Hi everyone, I'm an associate solicitor in the clinical negligence and personal injury department. I will be talking to you today about how to go about answering a question that has an element of clinical negligence. So if we go to the first slide. So what do you need in order to bring a successful clinical negligence claim? So there are 4 elements that you need. First of all, you need to establish that there was a duty of care. Secondly, you need to show that there was a breach of that duty of care. Third, you need to show that there was causation, so that the breach of duty caused the damage. And fourth, you need to show that damage occurred, so that an injury was sustained. I would always urge you to set out any clinical negligence answer in this order. So always go 1, duty of care, 2, breach of duty, 3, causation, 4, what was the damage. On the next slide, I'm going to go through an example with you. And it's really important, as Brad has already said, to set out how the law applies to the facts of the case. So in this example, I'll read it out to you. Maddie is 32 years old and is employed as a PE teacher in a secondary school. Maddie fell over whilst teaching her students and was hit on the head. She started suffering from severe headaches, vomiting and dizzy spells. One of her colleagues drove her to the local hospital and she was seen by a doctor in the accident emergency department. The doctor was coming to the end of their 12-hour shift and was tired. The doctor carried out a brief examination of Maddie and told her to go home and rest. Maddie went home to get some rest. As the day progressed, she became more unwell and started finding it difficult to speak. When Maddie's husband came home in the evening, he found that Maddie had collapsed on the kitchen floor and was unconscious. An ambulance was called and she was rushed to hospital. On getting to hospital, a brain scan was performed, which confirmed that Maddie had suffered a brain injury and she required life-saving brain surgery. Thankfully, Maddie pulled through the surgery but sustained life-changing injuries. She had problems with her mobility and was unable to walk unaided. She also had problems with her speech, memory and cognition. I will now illustrate how to answer a clinical negligence question by using this example. So on the next slide, I go on to discuss who the claim will be taken against and who the potential defendant is. So in clinical negligence claims, the person making the claim is called the claimant, and the hospital or trust or GP or doctor defending the claim is called the defendant. In answering your question, remember to identify who the defendant is. So, in the case of a doctor, nurse, physiotherapist, or other healthcare professional who's employed by the NHS Trust, the defendant will be the NHS Trust that has responsibility of the hospital. In the case of a paramedic who is employed by an NHS ambulance service, the defendant will be the relevant NHS Trust ambulance service. If your question involves a GP, the defendant will be the GP themselves and possibly the GP practice. In your question, there may not be enough information for you to be able to establish if there's 1 or 2 defendants. Write that in your answer. Say, if this happens, then potentially the hospital is negligent, potentially the GP is negligent. Just set it out. In the next slide, we go to the first element that you need to prove, duty of care. So in Maddie's case, did the accident and emergency doctor that she saw owe her a duty of care? Now, in order to answer that question, we need to look at the following. Was the harm reasonably foreseeable? So was it reasonably foreseeable that by Maddie attending the hospital with a head injury and not really being examined properly or receiving adequate treatment could have led to an injury? In our situation, yes, it was foreseeable that if she was not treated appropriately for a head injury, that an injury could have occurred. Was there a relationship of close proximity? So doctor and patient. In the case of healthcare professionals looking after patients, there's always going to be a relationship in close proximity. So yes, that's satisfied. Would it be just and reasonable to impose liability on the defendant in this case? So in our case, the hospital trust. Yes, it would be, because the doctor owed a duty to the patient, and a doctor's duty is to look after their patients and provide them with a good standard of care. The next slide I go on to discuss was there a breach of duty of care. So this is the second element that you'll need to show to prove clinical negligence. In order to answer that, what you need to show is that the care provided fell below a medically acceptable standard. And what that means is that no body of competent and responsible medical practitioners in the relevant field of medicine would have provided that level or type of care. So in Maddie's case, what we would need to show is that no body of competent and responsible accident and emergency doctors would have failed to have assessed Maddie properly. Should they have undertaken certain tests, scans, what treatment should they have provided? And if there were to be a body of doctors who agreed that the care provided by the A&E doctor was reasonable, then there may not be a breach of duty of care. However, in this case, given that the examination was brief and that Maddie was just sent home, it is likely, on balance, that we will find that there was a breach of duty. Again, always remember to apply the law to the facts of the case. The third element we need to consider is causation. So did the breach of duty cause the damage? The burden of proving the case is always on the claimant, and the standard of proof is what we lawyers call the balance of probabilities. Therefore, a claimant has to prove that it is more likely than not, i.e. there was more than 50% chance that the negligence caused the injury. In Maddie's case, we need to show that the doctor's failure to treat her led to her sustaining a severe brain injury. We need to show that had Maddie been treated when she first attended the accident emergency department, that that level of damage would not have occurred and she wouldn't have sustained the injury that she did. Again, apply the law to the facts of the case. The final stage, coming on to the next slide, is what damage occurred, or did any damage occur? So, and we need to determine, and by determining what damage there was, we determine the value of the case. So the purpose of compensation is to place the injured party, insofar as possible, in the same position they would have been in had the negligence not occurred. And in order to determine the value of the claim, we have to try and determine what position they would have been in had the negligence not occurred. So again, in Maddie's case, she was a teacher, sounds like she was married, had her own house, so she was obviously working and earning a salary, and it sounds like she was quite independent. But again, we'll probably need more information from Maddie or her husband to establish exactly what her position was before the injury occurred. Coming on to the next slide. Now, the two types of compensation that you can receive are general damages, and this is to compensate the claimant for the injury itself and any pain and loss of amenity. By loss of amenity, we mean things like if you have hobbies, such as playing football, and you can no longer play football as a result of your injury, that counts. The second type of compensation is called special damages, and these are damages for past and future financial losses. Past losses can include any losses incurred up until the date of trial, and future losses are any losses incurred from the date of trial up until the date of a claimant's death. So in Maddie's case, again, we would claim general damages for the brain injury itself and any difficulties that she had, and special damages for any losses that have been incurred and will be incurred in the future. Now, in terms of financial losses, these can include a variety of things. And remember, it's always to try and put the person in the position they would have been in had the accident or injury not occurred. So this person, as a result of their injury, may require care. They may have loss of earnings. They may have a travel and transport claim. It may be that they have lots of doctor's appointments that they need to now travel to. Or they may require a specially adapted vehicle because they can no longer travel in their ordinary vehicle. They may require aids and equipment. Their household expenses may have increased because they're spending more time at home. They may require therapies. or medical treatment, and the accommodation that they previously lived in may no longer be suitable, which may require adaptation, or they may have to purchase a new home. In Maddie's case, it's likely, given her injuries, that she's going to require care, and professional care that's going to be quite expensive. It's unlikely that she'll be able to return to work as a PE teacher. She's got loss of mobility and cognitive problems, so she'll have a loss of earnings claim. If she's wheelchair dependent, she may have a travel and transport claim also for a specially adapted vehicle. Again, aids and equipment. What kind of aids does she require to now mobilise around the house or just to get out and about? Household expenses. Maddie may have been responsible for all the DIY maintenance in her house before and all the cleaning, and now she may have to employ professional people to do all those things for her. Again, we can claim for those things. Therapy. Someone like Maddie, she probably will need lots of physiotherapy. She might need occupational therapy, neuropsychology. Those costs can also be included. Medical treatment. She may require surgery in the future, doctor's appointments, all of that can be claimed on a private basis. And accommodation, in Maddie's case, was she living in a 2-story house? Can she now access the top floor, or would it be better for her to move somewhere like a bungalow? Always apply the possible options to the facts of the case, and even if you think it does not apply, just explain why. I'm now going to pass you on to my colleague Chris, who's going to talk to you about criminal litigation.
Okay, thank you, Bella. So, my name is Chris, and I currently work in the criminal team. I'm a trainee solicitor there, and I'm going to go through 2 things with you today. The first of which is to give a little taster as to what it's like to be a criminal lawyer, and secondly, hopefully provide some tips that will help you answer the questions that we've set and provide a suggested structure for doing so. So, what does a criminal lawyer do? Broadly speaking, they're split into 2 parts, really. One is known as the defence solicitor. So they are the solicitors that represent the client denying the allegations. The second would be when you represent the Crown, known as the prosecution solicitor. You will be working alongside police and other prosecution agencies in order to secure a conviction. So, what might a defence lawyer do? And that's what we do at Kingsley Napley here. We are criminal defence lawyers. And I thought it might be useful to go through what we might do if we represented the bottle thrower in your scenario. So, for example, let's imagine that the student was arrested or invited to attend an interview at the police station. So we would attend the police station with them. Would have a meeting with the student and take their account. They would explain what happened, and then we would advise them as to their approach in the interview. And they might go no comment, which you've probably seen on TV, or they might provide a statement or answer all the questions. After that, the police have to make a charging decision, and that's based on whether they think there's enough evidence to secure a conviction. At that stage, if we can, we might conduct further research, gather further evidence, review the law, and if appropriate, we might make representations to the police to say, we don't think that you've got the required level of evidence, so you should drop the charges. A good result for our client, obviously, if we can get that. If they are charged and plead not guilty, then it will proceed to trial. And we would help in every aspect that we can in preparation for that. So it may be gathering evidence to back up the aspect of the student's account. It might be gathering evidence to undermine the prosecution case, speak to witnesses, hire an expert, or prepare documentation for presentation to the court. So overall, the lawyer's function is probably twofold in a criminal case. One is to protect clients' rights, and the other is to present their version or explanation of events in court or to the police. So we are often asked to give written advice, and I think you've been tasked with something similar. I would say at the outset, don't worry if you approach the question at first and think, this seems really hard, I've no idea how to do this. Because quite frankly, I often approach problems and think, this is really hard. But once you do a little bit of reading into it, hopefully you'll see that actually there is a way through it. And I would hope you might find it quite fun. It's a bit of a puzzle. And that's what sort of attracts me to it. So the first part, as you've already been told, is to consider the law. And we would always advise breaking it down into bite-sized chunks. Now, in criminal law, we call that the elements of the offence. So the elements are what the prosecution has to prove in order to secure a conviction, and the defence will be looking to show that the prosecution haven't proved all of the elements of the offence. The elements include the actus reus and the mens rea of the offence. They're two terms which we refer to in the fact sheet, but very briefly, the actus reus is the act that has to be committed to commit the offence. The mens rea is the mental aspect, the state of mind which is required in order to commit the offence. And you'll find also that sometimes the actus reus and the mens rea can be demonstrated by the same piece of evidence. Just something to be aware of. So if we take an example, I think you might be particularly concerned with criminal damage. And you'll see from the fact sheet that there are a number of elements that need to be proved. So the first is that the defendant destroyed or damaged. Number 2, property. Number 3, belonging to another person. For aggravated criminal damage, you'll notice that there's an additional element, which that the act endangered the life of somebody else. So take each element of the law and look at the facts to see whether it can be proven or not proven. And that is the sort of second stage to presenting a written answer, applying the law to the facts. So consider the facts as you understand them, and to see whether you think that the element has been made out. I would encourage you to look at it from the perspective of the prosecution and the defence. You may well notice that mens rea might be particularly hard for the prosecution to prove, because they have been tasked to prove someone's state of mind, something which is often incredibly difficult. But it's often someone's acts which can lead to an assumption about their state of mind. So that is one way that the prosecution may use to prove the mens rea. And so once you've applied the law to the facts, it may seem obvious, but state your answer in clear and simple terms. It's been mentioned already by both Tess and Sevim that you may come across situations where you think you don't quite have all the evidence, you don't quite have all the information. If that's the case and you notice that, great, let us know. Put it down in the answer and explain why it might be helpful to get that information. Perhaps suggest how you might obtain that information. And so finally, make a judgment. You will probably have heard of the phrase innocent until proven guilty. One of the things from TV which is actually true. And you've also heard the standard of proof. Sevim referred to the standard of proof, and in her line of law, it's on the balance of probabilities. Criminal law is slightly different, and again, you may have heard of this phrase, beyond all reasonable doubt. Now, it doesn't mean that if there's a small ounce of doubt, they're not guilty. What it means is that the judge or the jury has to be sure that the person committed the offence. So just bear that in mind when you're considering the facts, because that's the standard the prosecution would have to prove the case to. So I'm just going to hand you back over to Maeve for a quick summary.
Thank you all so much. That was really, really helpful. This webinar will go up on the portal, so if you miss anything or you miss any of the slides, don't worry, it'll be up there to watch it again. But there were quite a few themes that were quite similar to every area, and I think the main take-home point from this webinar will actually be how to approach the question. So you'll see on the slide now, first of all, use all the fact sheets. Although these three give an incredible insight into the three areas we believe are most important, there's loads of points to be picked up by looking at the other fact sheets, so make sure you check them all out. Secondly, identify the key elements of the law, so break it into manageable chunks. As Chris says, it is quite difficult at first, and it can be really daunting when you go through the scenario and think, oh my gosh, there's so much going on. There is a lot going on, and it's there to throw you off. But if you break it down into manageable chunks, you should be able to look at each element, ask yourself, what law is engaged here? And always show your working out, because if you think a part of the law doesn't apply, explain why. And we also ask that you sort of set out the law before you apply it, which is something that we do when we're giving advice as solicitors. So we'll set out what the law is to the client, and then we'll go through it in relation to the set of facts that we have. If there's information that's missing, don't be afraid to say so. The scenario is set out with a few bits that you might trip over. There's lots of missing information. So if you think there is any that's not there, just state that in your answer. And we would also ask that you should try and come to a conclusion or a judgment of some form. So if you work through the law and you apply it with the fact sheet at the side and you go, oh, I kind of think I know what's going on here, put that down. As long as you show you're working out, you'll be able to score the maximum points available. So I think that was what we all sort of thought about how you should approach the question. And as I said earlier, I don't know if you've all been sending in questions or not, but I will be there to field them to our panelists. If you've got any ones that you specifically want somebody to ask, just pop their name in the question and I'll do my best to get to it. So let me just have a look at a few of them now. So the first question is, what do you do if you don't know anything about the law?
Okay, I'll take this. Well, fear not. All the information that you need is in the fact sheets on the website and in this webinar. Everything that you need to answer the questions and get the marks that we think should be available are available to you. So don't worry about that. Yeah, and of course, you also have access to mentors at the firm. So if there are any questions that you're not quite sure about, or perhaps you feel haven't been covered, then feel free to just ask.
I wouldn't be too worried if you don't know much about the law. I think most lawyers' secrets is they don't know either. You've got to go and look it up, which is why we've put all the resources on the website. So the second question I'm going to ask to Chess, which is a bit more of a real life, what do you do in a real life situation? So what do you do if a client refuses to answer any of your questions?
I mean, I suppose the reality is you have to recognise that sometimes people are coming to you with very difficult problems, very personal problems, and there may be things that they don't feel comfortable discussing, or they don't understand why they need to discuss it with you. It might even be the first time someone has actually voiced their concern. So that can be quite a big deal for people. I suppose really it's the art of a good lawyer of getting people to open up, making them feel comfortable, making them trust you, making them feel confident that you're not going to judge them. You're just there to understand the facts, understand what they're trying to achieve, and help them realize that aim and get that goal. And what you tend to find is people may come through the door very nervous and quite clammed up and not prepared to talk, but as you begin
getting a relationship with these people, they start to open up a little bit more. People do relax. So it's quite rare that you would really get a client that wasn't prepared to give you an answer to a question, particularly if you explain to them why that answer is important, why you need it to be able to help them. So I think the reality is most clients are coming to you in a time of need, and they recognise that they need to be open and full and frank. So hopefully we shouldn't have that problem.
And something else you just asked, is the Maddie case completely hypothetical?
Oh, that
We're seven.
That's
sorry.
that's seven.
Sorry.
That's seven. Yeah, Maddie's completely made up. There have been very similar cases. One recently went to the Court of Appeal. So yeah, it is made up, but those kind of things do happen.
And just while you're there, another question that they asked was, how do you structure your answer to question 2? So that's sort of the longer one where you get an email from your supervisor. What would you do when you got something like that?
So if I got a long email from a supervisor asking me to look at certain things, I would again spread it out in chunks, identify the different areas of the law, be quite logical about it, apply the facts to the law, but really just break it down. That's the best way to do it, because your supervisor doesn't really want to receive back an essay. Usually your supervisor is going to be busy. What they want is the answer. They want it in summary. They want it quite clear, and they want it concise. So break it down and just be very clear about what advice you're giving.
That is really helpful. Thank you. I'm going to throw 2 more questions out to Chris because he is our criminal litigation representative. Chris, what do you do if you don't want to defend someone?
That is a question that you get asked a lot as a criminal lawyer. And it's not really a thought that crosses your mind, I don't think, as a criminal lawyer. You do have a duty to defend everyone that comes to you. And I suppose something which may make it easier to understand is the fact that you may not have to agree with what's allegedly happened or has actually happened. It's a case of protecting their legal rights, making their voice being heard in court. Everyone has a right to a fair trial, and so as lawyers, we are just part of that process.
I'll over some more questions.
That's fantastic.
Got lots of questions. Thank you.
Keep them coming in. One question I've got here is, what if your answer is different than the right answer? I think everybody would agree there's not usually a right answer in law. It's kind of how you argue it. So we have not got a set right or wrong answer. What we're going to give you marks for is applying the law and picking up as many points as you can from mentioning what's come up in the fact sheet. So if you and your friend have got different answers, don't worry, that happens every single day. It's how you argue it that we're going to be really looking for.
I think another thing worth mentioning, we were actually discussing this yesterday when we were preparing for the presentation. The reason that you have 2 sides to a legal case, so complainant and defendant, or employer and employee, or whoever it may be, is because there are actually 2 ways of arguing the same set of facts. So really, it's not about whether there's a right or a wrong answer. It's whether you're able to persuade the judge, the tribunal, whoever it may be, your supervisor, us, that you have looked at the relevant law, you've applied it properly to your facts, and you've drawn a sensible conclusion and a reasonable conclusion based on your assessment of the scenario. So that's why when we say don't worry about there being no clear right or wrong answer, that's often the case. That's how we're ending up in a job, frankly.
I think we've got a few questions about useful websites to look up. I'm going to say our website. It's where we put all the information that we think you need to answer the questions. On the fact sheets, there are little hyperlinks to other websites if you want to read around the subject. But we won't be giving extra marks based on that. That's not how we've set up the mark scheme. We set it up on the basis of the fact sheet. So you should be able to score really highly by just looking at our website. And another question is, what do you mean when you say show show your logic. What does that mean when you're giving a bit of advice?
What we mean is show how you reached your conclusion. So, like the example that I was going through, why would you say that somebody owes the doctor, Maddie? Why did the doctor owe Maddie a duty of care? Explain how you came to that. Show how you worked that out. It's a bit like when you're in school and you're doing math. They say show you working out. You show how you came to that conclusion. That's what we mean.
Yeah, and I think if you think about it from the employment law issue that I was discussing, you know, if you form a view that the teacher in your scenario was unfairly dismissed, it's not enough to say we think the teacher was unfairly dismissed. You need to go through the test that the school should have followed, the process that they actually did follow, the reasons that you think they formed, why you don't think those reasons are fair or proper, and go through the elements. So that's what we mean when we're saying, you know, show your working, show your logic, like Seven.
And I'll just add to that, one of the main advantages to doing that shows us how you've reached your answer. And it might not actually be an answer that perhaps we first thought of. But if you show us how you got there, you might think, wow, great. And that's what we were looking for.
I think we're unfortunately not out of time. Thank you so much for all your questions. I really appreciate how much people have engaged and given to today. So we've got through as many as we can. If you're not watching live, apologies, you won't be able to have got any of your questions. But if there's anything that pops up, please reach out to your mentors or check out the website, because hopefully it all should be up there. So the deadline for submitting your task one answers is the 15th of February at 5 o'clock. So unfortunately, any answers after that point will not be marked and you will not get to go any further in the competition. And I promise there are lots of fun tasks still to come. So it would be great if you could get your answers in even before then. So I think that's all we've got time for. Thanks so much, guys, for taking part. And thank you for watching. Good luck with the rest of the competition.
Thank you for tuning in.
Thanks very much, guys.